I see a lot of cases where it's a criminal case that really has nothing to do with firearms, but for some reason the police were there at that person's home, at that person's car, and then in the course of an investigation of another crime or another allegation, they find these firearms. And it oftentimes, finding the firearm becomes a way bigger problem than the initial reason the police were there. Welcome back to Boston Barristers, everybody, the podcast where we break down complex Massachusetts legal issues in a practical guidance you can actually use. I'm your host, Bill Manchinton, here today with Matthew Peterson, and we're tackling a topic that affects thousands of Massachusetts residents every year, firearm rights.
Luckily, it's a simple one, though, right? Not complex at all in Massachusetts.
Not complex at all. No, not at all. And, whether you're a gun owner, thinking about becoming one, or simply want to understand your rights, this episode is absolutely essential listening, because we're going to demystify one of the most confusing areas of Massachusetts law, how people lose their firearm rights, and more importantly, how they can get them back. Now, you might think losing your gun rights only happens after serious criminal convictions where you're found guilty. But actually here in Massachusetts, the reality is far more complicated. Here in Massachusetts, the system operates on two parallel tracks. There are federal prohibitors that create automatic disqualifications and state-level suitability determinations that give licensing authorities broad discretion. Now, we're going to help you understand the difference between these two, because understanding that can be the difference between keeping your rights and losing them. So today we're going to walk through the most common ways people lose their firearm rights, from felony convictions, domestic violence misdemeanors, to mental health commitments, or even just pending charges that haven't even been resolved. Then we're going to explore the often overlooked paths to restoration, including motions for new trial, pardons, expungement, and appeals through the district court system. Now, one quick note. We'll be touching on the pardon process today, but I will be diving a little deeper into that topic in the next upcoming podcast, so stay tuned for that. So whether you've lost your firearm rights and want to know your options, or you're just trying to stay informed about Massachusetts gun law, let's get started.
Sounds good, Bill. I'm excited.
Right. Yeah, let's do this. All right. So, I was talking about the difference between the federal prohibitors and the state suitability issues. You want to kind of give us an intro to the difference between those two?
Yeah. So there are prohibitors both in the state and federal. They're largely the same. That mean that if these things are true of you, then even if the police chief wants to give you your license, they can't. So There's a wide range of things like that. And then in Massachusetts, it's a shall issue state, but in actuality, there are a bunch of different things that the licensing authority, usually your local police chief, will be able to deny you a license for or suspend your license if these things are true of you. So that's usually under the broad term of suitability.
Right. All right. So great overview. Now let's dive into the federal prohibitors. What are the main federal prohibitors that automatically disqualify someone from owning a firearm?
So there's a felony conviction is a big one. So anything in federal law, anything punishable by more than a year is considered a felony. And that if you have a conviction of anything, of any of those crimes, then that is a prohibitor. That means that you cannot get a license to carry. Same is true of misdemeanors of domestic violence. Now, you might think a misdemeanor of domestic violence, that means a misdemeanor of domestic violence. But actually, there's more complications about what exactly that means in the statute as well. And you have mental health commitments. So any sort of, if you are drug commitment, so if you are committed to any sort of hospital by a civil process in a state, in here in Massachusetts, we call them sections, for either a mental health reason or a drug reason, like drug use, then that is also a prohibitor. Dishonorable discharge from the military is another one that's less common, but inside of each of those are a lot of nuances. I'm not sure how much you want to get into all the nuances. But
Sure, I guess. Yeah, go ahead.
Today's episode is brought to you by the law office of Matthew W. Peterson. If you're facing legal trouble in Massachusetts, whether it's an OUI, a firearm charge, or even just a clerk magistrate hearing, the stakes couldn't be higher. This isn't the time to go at it alone. You need more than just a lawyer. You need a legal team that knows how to fight and knows how to win. That's why people across Massachusetts turn to the law office of Matthew W. Peterson. With years of experience in criminal defense, family law, and immigration, we've got the track record and the passion to defend your rights. We've successfully represented clients in some of the toughest situations out there, from first-time offenses to serious felony charges. We've helped people protect their record, their families, and their freedom. So don't wait until it's too late. Visit mwpetersonlaw.com to schedule your consultation or call 617-295-7500. That's mwpetersonlaw.com and 617-295-7500. Because when your future's on the line, you deserve a legal team that's all in. Stay informed, stay legal. Now, back to the show. I mean, one of them that comes up a lot is the commitment on mental health and drugs. So a lot of people, sometimes they call us and they'll say, hey, I went to the doctor one time because I had a drug overdose. Can I get my gun rights? The answer is yes, unless a judge ordered you committed. You have certain rights in these situations. I know you've represented people who are facing these. I have too. Mm-hmm. But it's only a prohibitor if a judge ordered you committed to some sort of institution, usually a hospital.
I got you. I think one thing we should cover too is, how does Massachusetts handle the felonies different than federal law? Because we get that question a lot, right? What's a felony in Mass? What's a felony federally? What does it mean?
So yeah, a felony federally is anything punishable by more than a year, but in Massachusetts, it means anything punishable in state prison. Mm-hmm. Misdemeanors, anything punishable in the House of Corrections for up to 2.5 years. So how do those two things square? Well, the definition of felony in the federal law actually has a carve out for this specific purpose. And it's any misdemeanors that are punishable by 2 years or under, or anything that's considered a misdemeanor in state law that's punishable by 2 years or under, is actually not a felony and not a prohibitor according to federal law. So if you look at things like improper storage of a firearm, 2-year maximum penalty, not a federal prohibitor. Possession of a firearm without an FID card in your home or business, 2-year crime in Massachusetts, not a federal prohibitor. There are a lot of other ones like that, like, just they run the gamut here. But that's one thing that comes up a lot.
Right. And so you're saying, though, even a misdemeanor, if you are sentenced to 2.5 years in a house of correction, which wouldn't be a felony in Massachusetts, is a felony for federal purposes.
Yeah, and it doesn't matter what you were actually sentenced to. It matters what the maximum sentence is. So an OUI, for example, they changed it in I think it was 96 to increase the penalty for a first-time OUI from whatever it was before into 2.5 years. So now an OUI, even though it's a state misdemeanor, is actually a federal prohibitor. So if you have an OUI conviction, then that means that you cannot get a license to carry, and you can't even. And if
Let's
you carry
say that again. That's big, right? Yeah. So an OUI prevents you federally from ever owning a firearm.
Exactly. So an OUI conviction in Massachusetts prevents you. But one important thing, quaff is not a conviction for these purposes. So continuous without a finding, you get that, your case gets dismissed, assuming you complete probation, not a conviction for these purposes.
Okay, so let's cover that, because I think that's important. Conviction versus a quaff. Now, you said quaff that's an acronym, right? CWOF, which stands for continuance without finding. You want to just explain how that's different than a guilty plea?
So yeah, in Massachusetts, there's this weird thing called a quaff, where you basically admit to sufficient facts. You admit you're guilty, but the judge doesn't find you guilty. It's just it's weird legal fiction. But then, and you're placed on probation for a certain period of time. So usually the first time OUI, you get 1 year if you get convicted on a quaff. And that is, at the end of that period of time, the case is dismissed. So this doesn't count as a conviction for firearms purposes, but it does for immigration purposes. So
that is certainly
I know
true.
This isn't an immigration podcast, but
yes, you can see our other episode for that information. Now, I want to go back to something you said. You were talking about the domestic violence convictions. Now, sort of related to that, how do restraining orders factor into federal prohibition analysis?
So the way restraining orders work is if you're actually under a restraining order, there is a loss of license component. So in Massachusetts, they actually require you to turn over any of your guns and you'll lose your license to carry while the restraining order is ongoing. But after the restraining order is over, you're supposed to be able to get that license back. And this is actually something that there's a lot of federal litigation about this as well, whether that's even constitutional according to the Second Amendment. But yeah, basically, if you're under a restraining order, that's also a prohibitor.
Gotcha. Okay. And now let's cover another, let's say, common class of charges that may affect your firearm rights, and that is drug-related charges, right? So how does, let's say, a simple misdemeanor possession of marijuana, how does that impact firearm rights?
Well, misdemeanor possession of marijuana actually is not a crime in Massachusetts anymore, but you can imagine other states that have that. Yeah, a misdemeanor, right. If it depends on the state. So if we're talking about another state where misdemeanor or marijuana is still illegal, then yeah, that could also prohibit you from having a gun. Is any sort of drug conviction, things like that, even if it could potentially be a misdemeanor according to state law.
Okay, understood. So there are some charges that even when they're not going to be felonies can prevent you from owning a firearm federally. They're a federal prohibitor.
Yeah, so drug crimes, domestic violence, things like that.
Okay. So we've just covered all of the federal prohibitors, which are automatic disqualifiers, right? But even when you kind of get past all of those, we have to tackle the suitability issue here in Massachusetts. So I'm using the word suitability, and that's kind of the key word here in Massachusetts firearm law. Tell us what suitability is.
So suitability is a discretionary decision by your police chief to determine whether I believe the term is whether there's credible evidence that you possessing a firearm would create a risk to public safety. And it's more broad than the checklist of when you look at prohibitors. So it's broad. They can look at cases that were dismissed. They can look at cases that were never filed. They can look at restraining orders that were dismissed. And, any wide range of things. I mean, we get these calls all the time from people, and I'm always surprised by the things that these police chiefs consider finding someone unsuitable for. Like I actually had one where they found someone unsuitable for bringing their gun to a crime scene to check on a friend. Like they were carrying a gun. Luckily, the municipality in that case actually reversed themselves once we filed to appeal it.
Nice.
But it's a wide range of things. I mean, it can include everything under the sun, basically.
Right. And I've had a similar client as well who they had a license to carry, and just because they were in an argument, they had their license revoked, even though they didn't threaten anyone with the gun, they didn't shoot the gun, they didn't touch the gun, but it was revoked simply because they put themselves in an argument situation. So they can really revoke it for any reason. Now, whether or not that holds up in appeal in district court is another question, but they can revoke it for anything. So let's talk about some more of the suitability. So even, let's say, if you get past a federal prohibitor, right? Let's say you were under a restraining order and now the restraining order goes away. People will say, oh, well, I don't have a restraining order on me anymore. I get my firearm back, right? But that's not always the case.
Right.
Why is that?
Yeah, so they can look at the underlying circumstances of the restraining order. The police can, and actually on your criminal record in Massachusetts, a lot of times they'll have the affidavit from the restraining order there. And a lot of times police officers the licensing authorities will go pull the affidavit if it's not in your record to actually look at it and see what were you accused of here. Now, even if those things weren't true, even if they were disproven in court, they can still consider it. They can still say, yeah, you don't seem like a good guy because, this person in this restraining order said you did something bad, and it's just, it's very wide ranging. And even if the restraining order is over, so let's say there was a restraining order issued against you for a year, you had no problems with it. End of that year, the restraining order was terminated. They can still look back at that year restraining order and say, you know what, even though you're not prohibited, we're going to find you not suitable. And the biggest fiction about this, and I know we talked about this in a previous episode, is after 2022 and the Bruin decision, Massachusetts actually changed to a shall issue state from a may issue state, but it doesn't actually change anything involved on the ground. So it says shall issue if you're suitable. So shall issue if the licensing authority likes you is just as arbitrary and capricious as anything else.
Right. And those are the key words there, right? Because when we want to appeal a decision, we think that they have made a boneheaded decision to revoke someone's license without proper cause. Our argument to the district court on appeal is just what you said, that their decision was arbitrary and capricious. Because a lot of these police chiefs, right, when they see a police report, they just credit it automatically, right? And that's an issue because that's what the court system is for, right? With the juries and the witnesses to see, are we going to credit what's in the police report? That's why we have that system. But the police chiefs, they say, oh, well, I'm going to believe what the police report says. I don't care what the judge and the jury said. I don't care they found you not guilty. I don't care that they found the witnesses not credible. I'm going to revoke your license anyway. I mean, it's, as he said, arbitrary and capricious at its best, right? So it's a sticky situation, and really our only means of addressing that is if you appeal to a district court. But actually that isn't the only means. So let's talk about how we can restore the rights.
Well, there's one thing I want to make clear too is that say you're charged with a crime. Yep. The police chief actually could revoke your license immediately. And even before it's decided in court, even before anything else. And one thing I will just say anytime I talk about this on any forum, because this is a mistake I see so often, is if that happens to you, if you're charged with something, appeal your LTC suspension before the time period, even if there's a criminal case going. Don't wait until the criminal case is over. I've heard so many criminal attorneys say, oh yeah, just wait till your case is over and it should be fine. Don't do that. Okay. And also improper storage is another one that I think we should talk about too.
Yeah, let's talk about why. So let's cover those two things. Let's talk about why should you not wait till the case is over?
Because the statute gives you 90 days, and that 90 days is 90 days is 90 days. It doesn't matter whatever reason you have for waiting until afterwards. I mean, you and I did this. We tried to convince a judge down South Shore to extend the 90 days a little bit. And you and I kind of did every sort of backflip we could. And it's just pretty strict. Yeah. So what I generally do, and this is actually I just did this recently. I had a client who's charged with OUI and some other things. It suspended his license. We appealed, but we stayed the appeal until the criminal case was over. And then when we won the criminal case, we were able to do the appeal and get his license reinstated. Right. But if you wait, then you often have to wait until when your LTC was about to expire anyway, which could be like 4 or 5 years. So you don't want to wait that long if you miss that 90-day period.
Excellent point. And let's talk about the other topic you brought up, improper storage. And thank you for bringing that up, because I see tons of clients who thought that they were storing their weapons correctly, and they weren't. And I see a lot of cases where it's a criminal case that really has nothing to do with firearms, but for some reason the police were there at that person's home, at that person's car, and then in the course of an investigation of another crime or another allegation, they find these firearms. And it oftentimes, finding the firearm becomes a way bigger problem than the initial reason the police were there. And I'd say one of the biggest, or let's say most common problems, is the improper storage of a firearm. I've had clients who they own Glock pistols, and Glocks come in Glock boxes, and it looks like a plastic toolbox with clips, and there's some foam inside and you can close it. And people will have those or have that inside a backpack that's zipped up, and they put it in their closet. and they say, well, it's in a Glock box, in a zipped backpack, in my closet inside my home. I mean, that's properly stored, right? No, it's not. So why don't you tell me a little bit about what proper storage is then?
Yeah, so proper storage, a gun either has to be in a locked container or a trigger lock or on your person under your immediate control in order to be properly stored. So you can, carry it in a holster. You can carry it in your pocket, put it in your console, things like that. But it has to be under your immediate control or locked in some way, either in a trigger lock. I mean, there are some questions about like glove boxes, things like that, whether they can be locked. But yeah, It has to be in some sort of locked container according to Massachusetts law.
And to be clear, your home is not a locked container. Correct?
Right. Your home is not a locked container. Neither is your car.
Neither is your car. So those are two big points.
But there is one thing about improper storage that I used to have a law professor who would tell me, read the damn statute. It seems pretty basic. Like, read the law. You would think that lawyers, that's what we do. But there's actually an exception to this on suitability and improper storage. If you
don't read the statute,
what
is the exception when you don't read the statute? We shouldn't, or
no, you should definitely read the statute. And this is a good example. Like, I had a client who was charged with improper storage because he was literally like, he parked his car, went inside to the bathroom. It was one of those bathroom emergencies, and he forgot that his gun was in the center console. While he was inside, this gun was stolen. He called the police and said, hey, my gun was stolen. Sounds like he was being a responsible gun owner. They charged him with improper storage. They took away his license to carry.
Wow.
And there's actually a safe harbor in the statute that says if you report your gun stolen, they cannot consider your storage improper and cannot consider that for suitability purposes. So, and they could still charge you with improper storage, but they cannot consider it for suitability purposes.
And that's what they did. So there was a prosecutor out there who just thought, I'm going to get him for improper storage. And then Matthew Peterson walks in, reads the statute and say, hey, have you read this?
Yeah. I wanted to bring one of the books, like the old statute books down, put some, like, wipe the dust off the cover and be like, oh, let me educate you. But it wasn't actually a prosecutor. We won a clerk magistrate's hearing on it.
Oh,
and then to the licensing authority's credit, I pointed out the statute to them and they said, you know what? We'll give you guys license.
Fair. When you're right, you're right. So good on them for, recognizing that, not trying to, go after someone who didn't do anything wrong, right? Especially because you don't want to punish the behavior that you're trying to promote. Like, we want people to report stolen firearms.
Exactly. And that's the thing about it is that, because if the next person who comes along who's like, my gun was just stolen, I don't want the police to come after me, so I'm not going to report it. Exactly. So we want to promote that. I guess we talked a lot about how you lose your gun rights. Should we move on now to how to get them back? Yeah,
let's do sort of a hypothetical, I guess. Let's say someone is convicted of OUI after a jury trial.
Let's
just talk about, there's the first step. There's the first step. But hey, hindsight's 20/20. But so, like, what are some of our options, I guess?
So yeah, if you have a conviction of a crime, then you have several options. One is a motion for new trial. So you go in and you try to overturn your conviction. Usually it's going to be because your lawyer was ineffective is the most common reason, but there could be plenty of other reasons. The law is pretty broad as far as the interest of justice, but usually it's going to be, judge, you should give me a new trial because my lawyer, if he'd have talked to the neighbor across the street, they would have known I wasn't drunk. Or if they would have called, done this or that or the other. Usually it's in terms too of they didn't advise me of my rights adequately in a guilty plea. So things like that can be reasons to overturn a conviction. And
so something about the trial process went wrong, whether it was your attorney, whether it was the police investigation, prosecution, something was said to the jury that should not have been said. Mostly procedural issues or informational defects that require a new trial, but relatively rare. right?
Yeah, and it's pretty tough to get. And the other thing about it is that if you file your first motion for a new trial and you don't list everything, or you find out something later on that makes it better, they can say that you waive that second motion because you already filed one. So it's important that if you file a motion for a new trial, that you do it the right way, that you come legit with everything, and you talk to somebody and you figure out every potential reason. Because it's not one of those things you walk up to the clerk's office and say, hey, I want a new trial, and they hand you a 1-page form and you just check some boxes. There's got to be affidavits and things like that. It's pretty complex.
major process, right?
Yeah, it's one of those you got to put on your big boy lawyer pants and really get out
into
there.
it.
Yeah,
gotcha. So that's kind of rare. And there's got to be issues. So let's just say you were convicted of an OUI, everything procedurally was correct. You really were guilty of it. Is there anything you can do at that point?
Yeah, so there are two other common ways to restore your gun rights. One is an expungement. You have pretty much nowadays, you have to be under the age of 21 at the time of the offense for you to be eligible for an expungement. Otherwise, you have to show a fraud upon the court, which is a pretty tough thing to do, especially in your scenario where you just had like a first time OUI. So expungement, and then the other one is pardon. So you mentioned this earlier, we get a lot of pardon requests at our office, and a lot of times this is where we end up because motion for new trial, their lawyer didn't really do anything wrong, or their lawyer doesn't want to talk to us, or they we can't really figure anything out. So we go with a pardon. So why don't you, I know you said that you're going to have like a big expose on pardons at another time, and maybe you can give us like the basics of what a pardon is, how it works.
Preview, sure. So a pardon is essentially, it's going to be a request to the governor of Massachusetts to basically look at your criminal record and say, all right, I recognize what you did. You are taking responsibility for it and you're asking for forgiveness. And I, as the governor of Massachusetts, am going to forgive you. And another phrase that's used to explain that is called executive clemency. It's when the governor says, okay, you did something wrong, but I'm going to forgive you. And the reason why people try to get that forgiveness is it's not just sort of like a pat on the back. You actually get all your rights restored. So any right that was taken away because of those convictions, such as a firearm right, is restored when the governor sort of waves their magic wand and says, you're forgiven. Now, that's different than an expungement, because an expungement erases all record of that conviction or whatever it was. So if someone asks you about it, if it was expunged, you can say, I know nothing about that. It never happened. Now, the pardon is different in that the whole record's there, and you can't say, it never happened. It's more like it did happen, but I was forgiven, and any rights that were taken away, they're back to me. I have full civil rights restored. And like you said, for a lot of people who come to us who are looking for firearms to protect themselves, their family, or for recreational reasons, they have, one OUI charge. Or one assault and battery on a family member charge. And that's, other than that, they have completely clean records. And some of these people, they had, let's say in their early 20s, they had addiction issues. And so they pick up either a drug charge or an OUI, and they're coming to us at 55 years old, right? 20, 30 years later, completely different person with an entirely clean record for that entire time, and they're being denied LTCs. So that's when we offer a pardon to say, listen, you have a great track record from, you got that OUI, you were 22 or whatever, you were being stupid. You're 55 now, you have a career, family, and you haven't got into any more trouble at all. You volunteer in different organizations. You're a productive member of the community. Let's try to get you a pardon. And that is the best hope for a majority of the people who have criminal convictions. And
so how does it work? You said the governor has to do it. Do you just go up and ask her?
Yeah, you just go straight to her front door. No, so
just go up to the mansion and just knock. Say, can you pardon me, please?
Hey, you know what? something to just showing your face out of place, right?
Pounding the
No,
pavement,
please
right?
don't do that, though. Please do not try to harass the governor. It's not going to help you. But no, so Massachusetts, they have an official pardon application. And it's just a few pages, and you say, you know, what crimes do you want pardoned? What are your reasons for pardon? And then it asks you to include some documentation. And, you know, people can fill that out, and it's just sort of a standard form. But what we do is do an entire pardon application, a pardon presentation, where we do a lot more than just fill out the form, because what we want to do is attach a story, face, humanity to what currently is just a name on paper. So one of the requirements of the pardon application is that you have 3 character reference letters, and then a letter alleging your compelling need for that pardon. So let's say you had no UI in your 20s. We get letters from your boss, maybe from someone who helped you from Alcoholics Anonymous, and another letter from just an acquaintance or someone you work with, just saying, hey, this guy, you know, he's a role model. Whenever I need help, he helps out. Just a character reference letter. Those can go a long way, especially if you have a lot of people writing letters on your behalf. Now, you also need a letter alleging a compelling need. Like, why do you need this pardon? And if it's for firearms, you need something that's going to say, well, I have a compelling need for a firearm because I want to defend myself, or I want to use my firearm for all lawful purposes under the Second Amendment. Now, how strong your application is may depend on how much you need that firearm. But at the end of the day, it's completely up to the governor. Now, the governor has issued executive clemency guidelines.
Yeah, and that was one of the most impressive things about your applications, is that you actually go to the guidelines and you say, hey, this is what you say you care about, Governor Healy. This is why this person is perfect for what your priorities are.
Exactly. And you just reminded me of probably, you know, the strongest pardon application I've been able to put together in terms of Governor Healy's priorities. So each governor that comes in, they issue executive clemency guidelines. And Governor Maura Healey's really emphasized how corrupt or problematic policing was in the 90s in Boston, specifically regarding the war on drugs and the over-policing of Black communities. And so we had a pardon applicant who basically got caught up with drug issues in the early to mid-90s and truly inspirationally turned his life completely around from those days. Like, and I don't just mean he got clean and then just had a career and kind of took care of himself. I mean, he got clean and then went back into that community to help other people get clean or stay clean, stay out of trouble, and be a mentor for youth in that community.
Yeah, I know exactly who you're talking about.
So just way more than getting himself clean, it was really a community involvement, just an individual who gives so much of their time back to the community, back to the people who helped them, just to make sure no one else sort of falls into that trap. Now, this person lined up perfectly with Governor Maura Healey's executive guidelines. And I think that that application is, you know, one of our strongest. But that being said, oh, sorry, go ahead.
No, go ahead.
So that being said, you know, we put out these applications, but what people need to know is that there are no rules or regulations on how the governor has to handle these. There's nothing that says the governor has to read it, nothing that says the governor has to approve or deny it. The governor, it's completely at their prerogative. So if the governor never wants to read a pardon in their entire term of governorship, they don't have to. If they want to sit down day one and approve 5,000, they can. But it's completely on them. So we have to tell people, you know, we don't know if it's going to be reviewed. It could be reviewed next week. It could be never reviewed. But for almost everyone applying for a pardon, that is their last chance. So even if it's a 5, 10, 15, 20% chance, 50% chance of a pardon, that's still worth taking that chance. Because other than that, you will never receive a firearm in Massachusetts.
Yeah, or anywhere a lot of times.
Or anywhere, right, exactly. Because that record will be following you around.
So in one of the questions on the pardon application, which has really dogged me, and I've gone round by round with different police departments about it, is they ask you, do you have a letter from the police chief that says you're suitable? Right? Have you ever talked to a police chief about this?
I have not.
So I went back and forth with, I think it was Medford Police about it. And it's the classic catch-22. I said, hey, we need this letter to show that he's suitable. Can you do a suitability analysis for us? And a lot of times you want to know that too before you go into the pardon, to know, even if I get this pardon, am I going to have to then file an appeal in district court? Like, how much am I in for? And they said that in order to find out whether you're suitable, you have to have no prohibitors. Well, he has a prohibitor. He's seeking a pardon. But in order to get the pardon, you have to be suitable. So it's like, and I explained this to them, and I mean, they're just like, well, we don't care. Like, that's
there's
not
something, my stance on that is that, so we, since 2024 and the latest firearm decision, it's the shall issue state, right? So if it's a shall issue state and the only prohibitor is, because when people apply the first time, they get denial letters. And that denial letter has to state the reasons for the denial. So if they have that letter, I just put it in the application and say, well, so the denial was based on this one prohibitor.
Oh.
Once the pardon removes that prohibitor, there's no other grounds to stop the issuance of that license. And since it's a shall issue state, the license shall be issued. Yeah. So I don't believe that a letter from the police chief is actually legally necessary. Just because it really doesn't make sense. As you said, it's a catch-22. And if we are taking the shall issue language seriously, then once we remove, whatever was prohibiting you, it shall be issued.
Yeah. So it goes, the pardon application goes to the governor's council, and then they sort of make a recommendation to the governor, but there's really no timeline, no court date, no anything. Is that basically right?
Well, so they will schedule it for a hearing. And at that hearing, we can present our application. And then after that hearing, the board may recommend it to the governor. And then once the governor signs off on it, we're good. So right now, I am awaiting the scheduling of a hearing for someone who we are helping to get a pardon. And this is not the topic of this issue of this episode, but to get a pardon so they're eligible to remain in the United States. So we're doing a lot of pardon practice for either firearms or immigration reasons. But for a lot of our clients, pardons are their last hope.
Oh, yeah, definitely. And there's also one other way to get a license back that it's still in the books, but it actually doesn't even apply anymore, which is the Firearms Licensing Review Board.
Okay.
Have you
Tell
ever
us
heard
about
of
that? I heard of them. FLRB, yeah, of course.
Yeah. So actually the way it's supposed to work is that in Massachusetts, if you have anything that's under 2.5 years, it's a misdemeanor by the state. So like an OUI, things like that. There used to be this Firearms Licensing Review Board that would be able to look at it and say, okay, well, you had an OUI, but we're not going to really consider this a prohibitor. We're going to give you a license anyway. And there was like a board of people who would make this decision. But then the Fed stepped in. The Supreme Court was like, well, no, because the federal statute says anything 2 years or more. So what authority do you have, FLRB, to overrule this congressional act?
Yeah.
And if you look at if you look at the application for the FLRB, it actually says at the top, like this whole thing that I just said, yeah, you can apply if you want, but it's pointless.
Right.
Because the Supreme Court and the ATF have both said that even if we grant you relief for a state misdemeanor,
feds will still be coming looking for you.
Yeah, it's still going to be a federal prohibitor, and we can't actually give you a license.
Right.
So that used to be a way you might still hear people talk about it, but it actually doesn't even apply anymore, basically.
Okay. All right. So I feel like we've covered a decent amount of stuff in terms of how people lose their firearm rights and the avenues there exist to restore those rights. Is there anything I missed that you want to cover?
Yeah. So one other thing is that mental health commitments. So if you are sectioned in Massachusetts or in other states, and this gets so much more complicated when you look at other state convictions. So I always have to, I say, go talk to a lawyer and wherever the conviction happened, because I have no idea what the statutes mean, and I'm not going to sit here and try to guess. But a mental health commitment, there's actually a process according to the law to get that essentially forgiven as a prohibitor. You have to wait 5 years, and you have to have a petition in the district court. Now, I've never seen these things actually happen in district court, and I'm pretty sure if you went to a clerk, they would say, "What are you talking about?" And you would have to, like we were talking about earlier, bring out the old tome,
dusty statute,
the statute, and say, "This is what the statute says," and just set me up for a hearing in front of a judge where I can talk to them about it.
Right.
But there's actually a process for that, and you have to have a signature from a doctor who kind of vouches for you and says, yes, this person had mental health issues. It's been 5 years. They have no further mental health issues. So that is a way with that kind of rare circumstance that you had a commitment. And remember, a commitment has to be by a judge. There are ways that, like a 72-hour hold in a hospital, a doctor can commit you, but this has to be a commitment by a judge to be a prohibitor.
Okay, so if you check yourself in, doesn't count.
Right, unless somebody later petitions. And you would know if someone petitioned because you have the right to be there, you have a right to counsel, you actually have a right to appointed counsel too. So you would know if you had a mental health commitment. So we get that question a lot as well.
The mental health commitments, okay. Are there any other common questions that we get a lot that we haven't covered?
I feel like we get so many questions all the time that it's tough to think of anything off the top of dome, but to borrow a phrase from our esteemed colleague, Christopher O'Brien, who is stuck in divorce court today, God rest his soul.
Man, yeesh.
Not for him. He was a lawyer.
Right.
Yeah. So I think that we've covered basically the basic avenues to restore them. We have blogs on these. I know you've recorded videos, and I've recorded videos about some of these things as well. So there's a lot of other resources out there, but,
absolutely.
And what else I think we've covered everything, but
we've covered
any other questions?
Yeah. No, I think we'll just wrap it up. We'll say, thank you, everyone, for another great episode of Boston Barristers. Hope you have learned a lot about firearm rights, how you can lose your firearm rights, but also how you can restore your firearm rights. And of course, if you are looking for help restoring your rights, call me, call Matthew Peterson, call Chris O'Brien. We can help you out. All right.
Yeah, we do consultations for people. So you talk to other attorneys out there, or I talk to some clients who say, yeah, I called this firearms lawyer and he talked to me for 5 minutes and he just said, yeah, you're screwed, and hung up on him. And it's like, he doesn't want to take the time to review everything. They don't want to. So, but we actually will do paid consultations where we can review your paperwork and sit down with you and actually give you your options as well.
Right. And that is one thing I have heard clients say to us, is that during our consults, we explain the statutory scheme, what you have to do, all of that in a way that I guess other firms don't, for whatever reason.
Yeah, exactly. And sometimes, I would say that a good percentage of my consult calls end with, you don't need to hire me for anything else.
Right. Yeah. No, I told a guy today, you are not in a good position for a firearm, but I broke it down and here's why.
Yeah.
But at least now he knows, he doesn't have that burning question of, can I get a firearm, or can I not? So, but anyway, successful episode. Thank you very much, Matthew.
Thanks, Bill. Yeah, this was great, man. Hopefully we help some people out.
Absolutely. Until next time, everybody.
See y'all.